Hello everyone, we are starting now. The next lecture is Associate Professor Volkan Aslan. He is gonna speak on the topic Turkey's withdrawal from the Istanbul Convention from the perspective of constitutional law. Volkan Aslan is currently working as Associate Professor at Istanbul University, Department of Constitutional Law. And also he has a quite number of books and articles despite his young age. And also I personally thank him because he didn't spare his time and support when we asked for it. So the floor is yours, Mr. Volkan.
Thank you very much, Hassan, and thank you very much for your compliments. Actually, yeah, I might be considered as young, but I started to feel some kind of old, actually, especially after the constitutional developments in Turkey in the last 10 years, especially. But thank you very much for the compliment. First of all, I would like to say hi to all of the participants, and I would like to apologize because I couldn't join the other two sessions because I've been mobile all the day today, and I have just found the internet connection from one of the hotels, and that's why actually I have connected a bit late. So I would like to apologize from the two previous speakers for this. And before I start my lecture, I would like to thank my dear Professor Adem Sözer for giving this opportunity to me because it's my pleasure and my honor to make this presentation to this distinguished participants. And I also would like to thank them for sacrificing their time in this summertime. It's not easy actually to concentrate on lectures. So thank you very much. And I really appreciate your patience actually, the patience of the participants. As Hassan said, I'm working at Constitutional Law Department in Istanbul Law School for 10 years. And I have made some contributions to the books and articles regarding the issues in Turkey, the constitutional issues, especially that we have witnessed in the last years. And my latest pieces were about Turkey's withdrawal from the Istanbul Convention, the constitutional problems regarding it. And I have also written a lot of blog posts and articles regarding the COVID-19 measures in Turkey, actually, because unfortunately we have lots of constitutional problems, but these two issues are the hot topics for Turkey, at least for the last 1 year. And today I'm going to talk about the Turkey's withdrawal from the Istanbul Convention and the constitutional problems regarding this decision. You might be wondering why I'm making this presentation, because yeah, it's a bit boring subject, because I will talk about the technical issues. I will talk about the legality of the decision of the president and the legal base of it and the constitutionality of this act, actually. And especially for the foreign participants, this might not be attracting for you, but actually it should be, because yeah, I will talk about the technical issues in brief, but generally you will see that we have lots of problems regarding the withdrawal decision in the constitutionality and the legality of the withdrawal decision is very problematic. And this is important for other countries and the foreign countries as well, because Turkey was the main actor behind this Istanbul Convention. We have named this convention. We were one of the pioneer countries behind this convention. And it was held in the Turkey when we prepared this convention. We have attended the preparation of this convention. We have named the convention Istanbul Convention. And it's unfortunately very sorrow for us to withdraw from this convention, the convention which we named. And unfortunately, this would also trigger the other member countries to withdraw from the convention, especially when we follow the tendencies, the populist tendencies from the countries like the Poland or the Hungary and other countries in Europe and in worldwide. Unfortunately, our withdrawal decision might also affect or might trigger the other countries to take the similar decisions or approach. Actually, that's why this decision is important, not for only us, but for also the other countries in the world. So Now I will share my PowerPoint with you, and since I will talk about the technical issues, I will not prolong my speech very long because I know you are already tired, and I'm a bit unlucky because I'm the last speaker, and I understand you and your tiredness, so I will not take it too long, and I will briefly try to explain you what are the constitutional and the legal problems of the withdrawal decision in Turkey. Now I'm sharing my screen with you. I hope you see it. I have prepared a PowerPoint presentation for you. I think you see it, don't you? Currently, you must see it. Hassan, could you confirm?
Yes, we can see.
Okay, perfect. Büşra, thanks. Thank you very much. Okay, guys. So I would like to start with my headline, actually. What is it? It's Turkey's withdrawal from the Istanbul Convention and the constitutional problems of the unilateral presidential powers, Alla Turca. Why I choose this Alla Turca, especially this word is used by foreigners, especially during the Ottoman period, to describe the things that are done in Turkish way. And in Turkish, we also use it now, Alla Turca. Why I called this headline? Because you must have heard that there's a piano sonata by Mozart, and one of its parts is Ronda Alla Turca, and he named his part of the music as Ronda Alla Turca, and it's actually the mixture of the Turkish kind of music. So I use this word in my headline to describe and to create an image on your mind when you first look at it. We did it in a Turkish way. Actually, that's why I used this headline. Okay, and now, sorry. Okay. First of all, I would like to give you a brief timeline regarding the Istanbul Convention, our signature, ratification, and the withdrawal, and etc. Actually, Turkey signed the Istanbul Convention in May 2011, and we were the first country to ratify the convention in 2012. And the very surprising thing is about this ratification, we ratified this convention in our parliament with consensus, with unanimous votes of all political parties. And this is a very rare thing in Turkey, actually, because in Turkish parliament, you rarely see that some issues or laws or conventions are approved with unanimously. And then, unfortunately, with the president's decision in March 2021, he decided to withdraw from the convention. And as a legal basis of this presidential decision, the presidential decree number 9 was cited as the basis of this decision. And the withdrawal decision and its legal base caused very intense debates in Turkish communities since the decision was published in the official journal. In this lecture, as I said, the withdrawal decision, its legal basis, and related issues will be briefly evaluated within the framework of the Turkish constitution and the Turkish legislation. And for this purpose, I will first evaluate the withdrawal decision, then the Article 3 of the Presidential Decree number 9, which is the basis of this withdrawal decision. And by the way, last month, the Council of State, which is the competent authority to examine the legality of the administrative acts of the president, has issued a decision regarding this withdrawal decision, and unfortunately rejected it. I will also mention about it, and I will also criticize it, by the way. For evaluating the withdrawal decision and its legal basis, I will just give you a very general information regarding the Turkish presidential system and our administrative law system. By this way, I aim that you will understand the problems better. Yeah, since 2017, actually, we have adopted the presidential system. And actually, it's very new system for us because the history of the parliamentary regime in Turkey was older than the republic, actually, because we had adopted the parliamentary system during the Ottoman period. And with our first constitution dated 1876, actually, we had first adopted parliamentary system. And more than 100 years, actually, we used this system. But unfortunately, in 2017, there was a referendum, and with the votes of the people, we have adopted the presidential system. In reality, what does this mean? This means that currently our executive organ is just one branch. It's not divided into two branches because, as you know, in parliamentary and the semi-presidential systems, the executive organs are divided into two sides, president on one hand and the council of ministers on the other. And the council of ministers is generally responsible before the parliament, unlike the president. This is the general characteristics of the parliamentary and the semi-presidential system. But in presidential system that we have adopted, like the United States, there's only one person in the executive, and he can design, or he or she can design how she or he wants his executive organ. He or she is not responsible before the parliament. I mean political responsibility, not the criminal one. And he can do whatever he or she wants within the limits of the constitution regarding the executive organ. And he or she doesn't have the responsibility before the parliament. What makes the Turkish presidential system different from the US model is actually our Turkish president is much more stronger than his US counterpart. Why? Because in US presidential system, there are some checks and balances. Like, for example, most of the most of the acts of the president is subject to the approval of the parliament, for example, in United States. But in Turkey, we see much more limited inclusion of the parliament in presidential acts. Also, as you know, the party system and generally the state system in United States is very different, and the party discipline is not so high. So even in United States, the parliamentarians, the deputies, can decide contrary to the wish of the president, because this is the characteristic of the United States. But in Turkey, since we have very disciplined political parties, once the president has gained the majority at the parliament, there is even nothing to stop him from acting in a way that he wants. So there's only judicial body that can stop the president, but it's also problematic in Turkey because currently we are also having lots of problems regarding the impartiality of the judiciary, by the way. So yeah, we have presidential system, but it's completely different than the US counterpart, and our president is much more stronger than the US president. This is the first point. The second point I would like to tell now is about the presidential acts. The Turkish president has actually two different regulatory powers. One is the presidential decrees. Actually, these decrees are like the primary legislation in Anglo-Saxon countries. What I mean by primary legislation is the president can issue decrees about everything that are not covered by the statutes issued by the parliament. So while issuing a presidential decree, the president doesn't have to find a legal base. So he can regulate an area that is not regulated by the parliament. And on the other hand, he has the power to issue administrative acts. These are secondary acts, and they have to be based on statutes or presidential decrees. And these are decisions and bylaws and similar regulations. Actually, the withdrawal decision from the Istanbul Convention as a legal type is an administrative act and decision. And the legal base of this decision is Presidential Decree number 9. So after telling you this, now I can just start to evaluate the withdrawal decision. And please don't forget that since Turkey is a civil law country, our administrative law and the administrative system is very similar to the French one. If you know something about the French administrative law and other civil law countries, you might understand what I mean. In these countries, actually, for the administrative systems, the administration has to act and has to base their decisions on statutes or other primary acts. So in civil law countries and in Turkey as well, if you are issuing an administrative act, there must be a legal base. It might be a statute accepted by the parliament or presidential decree, and this is a specific feature of the Turkish presidential system, by the way. Okay. The most important regulation regarding the international treaties is in Article 90 of Turkish Constitution. And when we look at this article, I will not cover all of it, but I have just copied all of it to make sure that you see it. Actually, in the Constitution, there are two types of international treaties. For some international treaties, before the president uses his or her approval power, the parliament has to issue an approval law. Otherwise, the president doesn't have the power to approve the international treaty. On the other side, there are some secondary international treaties, and these are mostly about the technical issues. For these treaties, actually, the parliament doesn't have to issue an approval law before president wants to approve the treaties. So the Article 90 of the Turkish Constitution makes this distinction and separates two different types of treaties. But interesting point is when you look at this article, it contains regulations regarding the ratification and enforcement of treaties, but it doesn't contain a regulation regarding the withdrawal from the treaties. As I said, in terms of ratification, a dual distinction is made by the Constitution. While the ratification of some treaties is subject to the Parliament's approval, it's possible to approve the other treaties without the involvement of the Parliament. But unfortunately, the Constitution doesn't say anything about the withdrawal from the international treaties. But the presidential decree regarding the international treaties actually have more details regarding the approval and the termination of the international treaties. When you look at the Article 3 of the presidential decree, and which is actually the legal basis of the withdrawal decision of Turkey from the Istanbul Convention, we see that the ratification of international agreements and other issues can be decided by the president by presidential decision. The president can also terminate these international treaties as well. As you see, until now, we understand that the Turkish Constitution makes a differentiation between the treaties, but it doesn't regulate the withdrawal procedure. And when we look at the more detailed regulation in the presidential decree, we see that, okay, the president can ratify the international agreement. He can also stop the implementation of them. He also can terminate them. But as you see, in this article, there is also not a distinction between the treaties. So the legal problem actually just occurs here. What if a president wants to terminate a treaty that was already approved by the parliament? Actually, our constitution nor the presidential decree doesn't answer this question. And this was the problem that we have faced in the withdrawal of Istanbul Convention. The interesting point is, guys, actually, before Turkey adopts the presidential system of government, these issues were regulated in a statute accepted by the parliament. But in the repeal law, no distinction was made between the treaties that are subject to parliament approval by law and those that are not in terms of withdrawal. But the system was actually not that much problematic because we were not using the presidential system of government. We had the parliamentary system of government, and the Council of Ministers was politically responsible before the parliament. So it was not possible for the Council of Ministers to act contrary to the will of the parliament because it was responsible before it. But currently, the president is not politically responsible before the parliament. The second problematic issue is actually the authorization problem. Because as I said to you, before the adoption of the presidential system in Turkey, the main regulations regarding the approval and the termination of the treaty was regulated by parliament with statutes. But currently, these issues are regulated by a presidential decree. This is also another problematic side of this withdrawal decision. And I think a few slides later, you will understand it better. I know it's a bit complicated now because it's a technical issue, but you will understand it. This is a citation from Law No. 6284, which is about the protection of family and the prevention of violence against women and administrative principles. Actually, this is our internal statute. And we have adopted this statute after the ratification of the Istanbul Convention. What is problematic in Turkey now is, in this law, there is still we still mention about the Istanbul Convention. When you look at the basic principles that should be complied during the implementation of this law, it says that the Constitution of the Republic of Turkey and the international conventions to which Turkey is a party, especially the Convention on Preventing and Combating Violence Against Women, and other applicable regulations shall be taken into consideration. What does this mean is actually, you must remember, as I said to you, we are civil law countries. So in order to make an administrative decision, all the administrations in Turkey, including the president, has to base his decision on statutes. By withdrawal decision, the president actually terminated the Istanbul Convention for the Turkey, although the parliament didn't issue any approval law, because before we ratified the Istanbul Convention, the parliament had already issued an approval law, but the president terminated the Istanbul Convention without issuing any law by the parliament. This was one of the problems of the authorization. And the second problem regarding Turkish law is, currently we have internal statutes which actually mentions about the Istanbul Convention, and this law is also binding for the administration in Turkey. So, according to me and most of the constitutional lawyers in Turkey, if the Turkish Parliament doesn't change this law and doesn't erase the Istanbul Convention phrase from this law, it's not possible to withdraw from the Istanbul Convention with an administrative act. Because as I said to you in the beginning of the presentation, we are civil law countries and our administrative decisions has to base on statutes or presidential decrees. But currently we have an internal statute and it says that while implementing this law, all the authorities have to use and execute the articles of the Istanbul Convention. This is also contrary to the legal principle, actually, which is a parallelism. Parallelism in form and procedure. This is an administrative law principle, and it says that unless there's a contrary regulation, the rules of form and procedure in the execution of an administrative act must also be followed in the cancellation of or withdrawal from the administrative act. But as I said to you, although there's an approval law regarding the ratification of the Istanbul Convention, the president terminated this convention without issuing any new law by the parliament. And the second most problematic issue is, currently, our law regarding protection of family, especially and briefly but explicitly mentions about the Istanbul Convention. So currently, most of the scholars in Turkey says that even the president withdraws from the convention, because of this law, the public authorities in Turkey still have to observe the articles of the Istanbul Convention. But when we look at to the implementation and when we look at to the public discourse made by our governors, actually, it seems that they do not care actually this regulation which cites Istanbul Convention. So guys, by saying this, I have finished the first part of my presentation, which is the longer part, by the way. And as you see, for our law system, this withdrawal decision is completely contrary to the constitution and contrary to the law. Now I will just give you brief information regarding the legal base of the administrative decision. As I said to you, the president used his power to withdraw from the convention by citing the presidential decree, which actually regulates the termination of the treaties, as I mentioned to you a few minutes ago. As you see here, we see that the President of the Republic may issue presidential decrees on the matters regarding executive power. This is the article from the Constitution. But the problem is, what are the matters regarding the executive power? According to Constitutional Court, the regulations which are not related to the legislative and judicial power, actually, these are matters regarding the executive powers. And the Constitutional Court gave a decision before this Istanbul Convention argument, actually, 2 years ago. And in this decision, Constitutional Court said that the treaties which are not secondary in nature and which do not need the approval from the parliament, actually, the regulation of these treaties falls within the presidential decree domain. So the president can regulate these treaties with decree. But the problematic side of this decision is when we compare this decision with the events that is happening in Turkey now, the Istanbul Convention is not from the treaties that Constitutional Court cited here. And actually, the Istanbul Convention has an approval law by the parliament. So in my opinion, the president doesn't have the power to regulate the treaties which are subject to the parliament's approval with presidential decrees. So what I mean is both the withdrawal decision from the Istanbul Convention and the legal basis of this withdrawal decision is completely contrary to the Constitution. Up until today, actually the Constitutional Court didn't give a decision regarding this presidential decree, because in our law system, the Constitutional Court cannot execute the constitutionality of the statutes and the decrees on its own. So it has to receive applications from certain people in order to examine the plea of unconstitutionality. But unfortunately, up until today, there was not any application to the Constitutional Court regarding this presidential decree. But against the decision of the withdrawal, actually, most of the people and the legal organization in Turkey applied to the Council of State. What is Council of State? Actually, it's similar court we see in France as Conseil d'État. Actually, this court is the highest administrative court in Turkey. But unfortunately, the Council of State, DANIŞTAY in Turkey, rejected this application because according to Council of State, now I'm trying to find the decision, just a minute. Yeah. According to Council of State, request for the suspension of this presidential decision on withdrawal from the Istanbul Convention was rejected by the majority vote. And also the Council of State said that the unconstitutionality plea, the plea of unconstitutionality regarding the legal base of this presidential decision was also constitutional, and it also rejected this PLEA with majority vote, by the way. According to the Council of State, regulating withdrawal process from the international treaties with presidential decrees is not contrary to the Constitution. But guys, the court didn't make the distinction that I have mentioned to you. As I said to you, in our Constitution, neither in our other presidential decrees or statutes, there is not distinction regarding the treaties require the approval from the parliament and the treaties that do not require that kind of approval. And actually, Council of State didn't even mention this distinction in its decision. And unfortunately, this decision also attracted lots of criticism from Turkish academia as well. And the sad point about this decision is, guys, this decision was taken by 5 judges, and it was taken by 3 to 2. So with the majority votes, actually, the Council of State rejected to examine the constitutionality and legality of the withdrawal decision and its legal base. So I don't want to prolong it too much, but in this lecture, the decision to withdraw from the Istanbul Convention and its bases were examined in a technical way. But even if none of these above mentioned problems had occurred, it could still be said that a withdrawal decision in question is problematic. Why? Here you see the citation from the general characteristics of the Turkish state, actually, which is regulated in the 2nd article of the Constitution. As you see, it says that the Republic of Turkey is a democratic, secular, and social state governed by rule of law within the notions of public peace, national solidarity and justice, respecting human rights, loyalty to the nationalism of Atatürk, and based on the fundamental tenets set forth in the preamble. In a state where rule of law and human rights are respected, every progress on rights is actually like passing forward through a turnstile. So, as one cannot go back after passing a turnstile, there should also not be step backs in the universe of rights, because, as we say, Turkey is a democratic and respecting human rights state. And in this respect, the ideal attitude for Turkey, of course, in terms of constitutionalism and human rights, is not to be satisfied with the Istanbul Convention, but to adopt more qualified regulations. Actually, it's a bit self-contradictory to withdraw from a treaty that imposes the minimum obligations and to state that the domestic law provides a better protection. Yeah, when you look at the public discourse of our politicians and the governors, they say that we have withdrawn from the Istanbul Convention because our internal law is better. But why? If it is accepted that the domestic law contains better regulations, there is no legal meaning to withdraw from the Istanbul Convention because it sets the minimum requirement. So briefly, we can say that unfortunately, for the political reasons, maybe for a few votes, we have sacrificed the Istanbul Convention. And by doing this, we have also violated the basic principles regarding the administration in Turkish law and the Turkish constitution as well. So, as I said, even if it was a legal decision, that would be problematic by for the 2nd article of the Constitution. But we also did this contrary to the Constitution. Thank you very much. And I really want to thank you for your patience in this summer day for listening to this legal stuff. So if you have any questions regarding my presentation, I'm waiting to answer it. Thank you.
Thank you, Mr. Volkan, for such a detailed presentation, even if it was a technical one, but it was quite clear for all of us, I suppose. So the first question was coming from Deniz. She is asking, as you have pointed out, the withdrawal from the Istanbul Convention is against the Constitution of the Republic of Turkey, which legally would mean that the withdrawal is not valid. However, the Council of State rejecting the application regarding the withdrawal decision indicates that The court actually does approve of the withdrawal. My question is, can a judge still make rulings based on the Istanbul Convention as a decision is against the Constitution, or has the ruling from the Council of State make it impossible for a judge to make rulings based on the Istanbul Convention?
Thank you very much for the question. Actually, it's a bit complicated issue. First of all, when the president issued his withdrawal decision, most of the people in Turkey actually said that this decision is null and void, so it doesn't have any meaning. Istanbul Convention is still in force for Turkey, etc. This is not true. Unfortunately, from the international perspective, we are not part of Istanbul Convention anymore. The problematic part is we have taken this decision contrary to the Turkish law. And the problem is when you look at from the outside of Turkey, yeah, this is a valid decision because the president has the power to represent Turkey in international affairs, and the European Council of Europe doesn't examine the internal legality of this decision. So currently we are not part of it. And according to Article 90 of the Turkish Constitution, it says that the international treaties to which are Turkey party, these have the force of law, force of statutes, like accepted by the parliament. And in case of quarrel or in case of conflict between the treaties regarding the human rights and the Turkish statutes, it says that the international treaties will be applied. But unfortunately, currently Istanbul Convention is not in force for Turkey. But the funny part is, as I said, currently we have a law. It's 6284, the law regarding the protection of women and the family. And in this law, it cites the Istanbul Convention explicitly. So if I was a judge and see that there's a dispute that coming in, a file comes to me and regarding the implementation of the Istanbul Convention, actually I would prefer to use its articles because there is still open citation to Istanbul Convention in Turkish court. But this is the legal base. If Parliament changes this code and erases this Istanbul Convention phrase from this code, it would be impossible, by the way. And I would like to also say that the decision of the Council of State regarding withdrawal decision is not final, by the way. It was just decision on the request for the suspension of implementation of the withdrawal decision. The Council of State refused this, but it will give its more detailed decision in the following months. But currently, as I said, from one side, we are not part of Istanbul Convention anymore. But on the other side, there's still explicit citation of Istanbul Convention in one of Turkish courts. So I think it could be actually used as a legal base. Yeah.
Thank you. The second question is coming from Merve Melis Karakoç. So what awaits us next? If this decision is to be corrected in the future, is it possible to make a retroactive correction, or is it possible for us to become a party to convention again?
In Turkish law, unfortunately, the decision of the Constitutional Court are not retrospective. So what does this mean is, for example, as you know, the Constitutional Court has the power to invalidate the laws. But before this invalidation, all the things that are done basing on this law is valid, actually. So if a court says that, if a constitutional court says that, okay, the legal base of this presidential decision is contrary to the constitution and I invalidate this decree, and if Council of State says that this presidential decision regarding the withdrawal from the Istanbul Convention is contrary to the Turkish law and the constitution, and if it invalidates it, unfortunately, these decisions do not mean anything after that. They could just impose a political pressure on the parliament, maybe to issue a new law regarding the approval of the, reapproval of the Istanbul Convention. So, as I said briefly, if these decisions are invalidated by the Constitutional Court or other courts in Turkey, they are meaningless because we are no more actually parts of the Istanbul Convention. The political decision must also be given again to be part of the convention. So actually, from this point on, the courts do not have lots of things to do actually. All the stuff is on the shoulders of the politicians actually. This burden is on them.
Thank you. From Hilal, in addition to Merve, I also want to ask if the presidential decree that 3718 numbered presidential decision based on annulled by constitutional court, would it mean that the 3818 numbered decision would also be annulled? What will happen?
Yeah, actually, as I said, in Turkish law, the decision of the Constitutional Court is not retrospective. And even the Constitutional Court invalidates the legal basis of the withdrawal decision, which is a presidential decree. That doesn't mean that all the decisions which are taken based on this presidential decree will be automatically null and void. In Turkish law, we don't have this. So even the legal basis invalidated or annulled by the Constitutional Court, unfortunately, the withdrawal decision will be still legal.
Thank you. Do we have another question? I think that would be all. So thank you very much for taking a break from your holiday and giving that such a beautiful presentation. Thank you, Mr. Volkan.
Thank you very much, Hasan. It's my pleasure, actually. And it's also keep me fresh by joining that kind of organizations when I'm on holiday, because you are also a worker of the Istanbul Law School, and all the academicians who are working in law school, Istanbul Law School, actually never go to holiday. And this is one of the features that differentiate us from the other academics. And I would also again thank to my dear Professor Adem Sezer for giving this opportunity to me. It was my pleasure to make this presentation to you. Thank you.